You are Juan Jose Serna. Mr. Serna, you now stand charged yet again with burglary of a motor vehicle.
Natural for legal burglary in a crowded parking lot. Witnesses at the scene and a suspect caught red-handed almost step into this probable cause hearing where every detail, from a camouflage hoodie to a flathead screwdriver, is under the microscope. Will the evidence hold up? Watch as the prosecution presents their case.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of a parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness' motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to a motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking up, jumped out of her motor vehicle, got into the passenger side of the waiting vehicle with an unreadable plate, and the complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect's motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr.
Yeah,
Serna is the second. Looks like the second individual that was in the that was in the driver's seat whenever the complaining witness came out is not the owner of the vehicle.
So if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client. So I'm saying that there's no probable
They have both of them in the car, being car.
The both of them in the car.
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
Were in the car attempting to.
I have the
Because I thought I read that one person wearing a camouflage hoodie was in the car.
That was the second one. So the first person goes in, gets out, and that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off. Mr. Serna, let's go through your stuff. Theft of wire or cable, theft, trespass, evading arrest, evading of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time after.
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at 10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at 10,000. I'm asking the court to just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In
the
felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If, I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Serna. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a SCRAM monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Who got the co-defendant? Do we have the co-defendant? No contact with the co-defendant, please, Felicia.
Still loading, Your Honor. I apologize. We have the co-defendant, Your Honor.
Say it again.
I'll sit on the 14.
Let me ask you this. You ever had a job before? Like a full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years.
So I have talked to pretrial in regards to the violations. It's to tampering with the SCRAM.
You need a translator anyways, right?
I guess
Enrique
so.
Ramirez?
Yes. So pretrial doesn't know exactly what was tampered with. He does work in construction. He
Reportedly saying it was just skin cream and a pair of supports. Will the judge believe it? Watch this release to see if explaining away any unknowns about can rubbing on SCRAM alcohol monitoring devices is legendary enough, or if the harsh truth will be revealed.
wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says that SCRAM actually has been causing him a lot of pain on his legs, so sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no DAC, no alcohol, nothing. It was just
Because a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor this is Enrique Ramirez.
This was
A lot of times they'll say the tamper was from midnight to like 6 a.m. so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one,
And it says alcohol was detected.
on March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first.
I don't know what to tell you, Ms. Solis, but
Oh, I mean, pretrial doesn't have knowledge as far as like what was tampering. I mean,
they can't. It's impossible.
I know that, Judge.
It is, all we know is that the device was not detecting his skin for certain period of time. And at the same time, alcohol is detected.
Ocho.
So let's do this. I need to get a translate here so I can properly translate and let him know what I'm going to, oh, Blasa.
Yes.
Can I borrow you for a second, please? No, I just need you to help me translate.
Oh, okay.
Mr. Ramirez, you were instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I know, Judge. I mean, we're ready for plea today, but
you're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
So Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back. And we'll see.
Yeah, because he does use the creams on his arms and hands, so it doesn't have a BAC level or anything in regards to the SCRAM, so.
Advised of.
I understand, Judge, I understand.
All I know is that alcohol was detected and he's tampering with the device. All
Judge, all right, well, so I'll step out and then, thank you.
right. Good morning, ma'am.
Hi.
Just a little bit down so I can see your eyes.
Sure.
That's okay. How are you?
Good.
Ma'am, you've now picked up another case. You're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford it, one will be appointed to you.
If I can just confirm the name.
Agbacielo.
On April 1st, 2025, a law enforcement officer was dispatched to a residence in Harris County, Texas regarding a disturbance. A law enforcement officer made contact with the complainant.
The judge appeared concerned when he heard about the defendant's dangerous history. What happened in the past? Could a lightning strike threat lead to obesity? Let's explore this tense hearing.
Second complaining witness who stated that he was inside the apartment when he heard the first complaining witness outside getting yelled at by the defendant. The second complaining witness went outside to see what was going on, and the defendant yelled at him to stop putting things in the pothole in the parking lot. The second complaining witness told the defendant he was fixing the hole, and then threatened both the complaining witnesses, pointing at them with their fingers, making a pistol shape with their fingers, saying, "I'm going to shoot you."
Wait, you said there were two complaining witnesses.
Yes, Your Honor.
Okay.
That's what I have here. It says, "I'm going to shoot you," towards both complaining witnesses.
And we have Ms. Agbacielo making the alleged threats.
Correct, Your Honor.
Okay, who is the complaining witness? Is it a known person? Because we have priors with Ms. Agbacielo and there are assaultive and, pretty dangerous priors. Any of the same complaining witnesses?
Does not appear so, Your Honor. I'm looking through. No, they aren't. It's like, it's just, from what we can see, it's.
Was it a street worker? Was it someone working for the city or
It's someone that lives there, Your Honor.
just out there fixing the potholes?
That's correct, Your Honor.
Okay. I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand, ma'am?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer, ma'am?
Yes, Your Honor.
Okay. We can give you time. So what I'll have you do now is I'll have you sign a receipt of Victoria while you take a seat, while we draft the bond conditions, let you sign it, and after that you'll be free.
Yes, Your Honor.
Please, ma'am, don't pick up any new cases. Just don't have contact with these people. I don't want to have to put you in jail.
Your Honor, it was the same thing the last time, the
Just,
last case.
just please be careful,
Yeah.
Really.
People make false allegations all the
And
time.
I get it. There's always two sides to the story. That's why you have a lawyer. That's why we'll give you time. But the evidence will point to whose side is correct.
Yeah, and I
You
do
know,
have them.
So please.
Thank you.
Yes, ma'am. Good morning, Mr. Kyles. Sir, you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you, sir.
A year in jail and a $400 fine await. The judge has issued dire warnings about drug use and possession of weapons. Will rehab listen, or will there be serious consequences?
On April 2nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an apartment complex and spoke to a complaining witness who said that she was laying in her bed and was awoken by her son, the defendant, screaming, and then she heard 2 gunshots go off in the apartment. The complaining witness then got out of bed and took the gun from the defendant, hid it, and called 911. Upon arrival, the law enforcement officer recovered the weapon, along with 2 fired shell casings and 2 fired slugs matching the caliber of the pistol fire. Upon contact with the defendant, the law enforcement officer noticed the odor of alcoholic beverage and that the defendant was wet while fully clothed. The defendant stated he had
Defendant was what?
wet while fully clothed.
Wet while fully clothed. Okay.
Sure. The defendant stated he had been drinking alcohol and smoking marijuana and that he fired the firearm in the apartment. The defendant said he was wet because he dumped a bucket of water on himself. The defendant stated that he was paranoid at the time.
Mr. Collins, I'm sending you for a drug test. I want to know what if anything was in your system. You're to come right back. I will appoint you a lawyer today, but you're not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. You're also not to be in possession of weapons. Do you understand? So do you guys have a rip done on this case? Do we
Yes, Your
know
Honor.
whether she wants him back at home or no?
I made contact with the claimant, Your Honor, however, she did not wish to talk with me about the incident after.
She want to talk to you?
No, Your Honor.
Okay. Don't be in possession of weapons, Mr. Kiles. You know, I don't want to have to put you in jail and make your bond high. I don't know if you have anyone in this life that is prepared to pony up $5,000 to $10,000. So when you're out there in the free world, if you don't have anyone that's going to, you know, pony up that money for a bond, you'll be stuck like Chuck in there. So be careful. All I want is my city safe. You understand? Okay, so what we'll do is I'll appoint you a lawyer today. Or do you have the ability to hire a lawyer or would you like a court-appointed lawyer?
You can appoint me a lawyer and I may consider hiring one if the understanding is not
I
understood.
just want to know whether you want a court-appointed lawyer or not.
Yes,
I
sir.
can
Yes,
appoint you a
sir.
lawyer today. I'm sending you for a drug test. I want to know what if any in your system. Come back and then I'll have a lawyer waiting for you.
Okay.
Okay.
Judge, financial affidavit or no?